Hello and welcome to Law and Life Matters, the podcast that explores legal issues and how they affect our everyday lives. I am your host, Mutimele, and today we'll be diving into the exciting topic of entertainment law and intellectual property. To help us unpack this topic, we have our guest today, Mdakane, and I'm just going to tell you a little bit about Bongani. I'm going to read his bio for you because I don't want to butcher it. So Bongani is an attorney with 12 years experience. He holds a Bachelor of Laws degree from the University of South Africa and a postgraduate diploma from the University of Johannesburg. He started his career as Spur and Fisher, where he specialized in trademark and copyright law. Later, he worked as a commercial legal advisor at LexCorp as well as at Clientele Legal. Thereafter, he joined South African Music Rights Organization, commonly known as SAMRO, and Ambitious Entertainment as a legal and business affairs manager. He also joined the Composers, Authors, and Publishers Association as a non-executive director. Some of us we know of the organization as Capasso. Bongani was also part of the team which made written submissions to the Parliamentary Portfolio Committee on the Copyright Amendment Bill. Currently, Bongani founded Mdakane Attorneys in 2023 to further practice in an all-encompassing manner. Good morning, Bongani. Welcome to Law and Life Matters.
Hi, Isabella. Thanks for having me.
It is our honor to have you today. So just to get us started, I'm curious. If you had to pick a fictional legal character to have dinner with, who would you pick?
Fictional legal character.
Yeah, or somebody who plays a legal
remember
character in a series or movie.
Better Call Saul?
Who?
Do you remember him from Breaking Bad? He's I don't know if you're familiar with Breaking Bad, the series
I'm not
Breaking Bad.
familiar with Breaking Bad, but you can tell us about him and why.
So he was the lawyer there, and they actually made a spin-off off of him. He was a throwaway, not really throwaway, but he was nowhere near being the main character on Breaking Bad, but they made a spin-off based on him.
Oh.
And what I like about Saul is that he was the yeah. What I like about Saul is that he was the underdog. His brother was a partner at a prestigious law firm, and Saul started in the mailroom. You know, um, what I also like about him is that the series focused. They didn't focus on the glamorous side of law. He was actually a struggling lawyer, which is a better reality, at least in South Africa. You know, so I identified with that. Saul was actually looking for offices. You will never see in an American series where they depict you looking to share office space and all of that. So I identified with Saul.
That is so interesting. I had no idea
Yeah.
that such a character exists in Breaking Bad. I might check it out after this podcast. And if
You can even start with Better Call Saul and you'll understand it without watching
Okay.
Breaking Bad. I highly
Okay.
recommend it.
Okay,
Yeah.
thank you.
Yeah.
Now, music, film, and television and beyond,
Mhm.
entertainment law plays a critical role in protecting the creative works that entertain and inspire us. Can you tell us what are the main types of IP rights that apply in the entertainment industry in South Africa, and how do they differ from other industries such as the science and technology industries, for example?
Okay. So basically, just to answer your last question, they differ in other industries in the sense that they are protecting mostly talent and the fruits of those talents. know. So the main law that will apply in the entertainment sphere is obviously before IP, I would think contract law, you know, because it's highly governed by contracts and so forth, like many other industry, I imagine, I guess. But then the works that are created from the talent will usually attract copyright, right? So the scripts and the manner in which the scripts are depicted and whatnot will be subject to copyright protection. And the name of the assets that comes out, the assets which come out of these things will also protect trademark protection. On top of that, this is not so much IP, but it's common law. There's personality rights as well, that come from these sort of works. So there's a lot of, entertainment law sits at the intersection of various laws, actually, which all speak to each other.
Okay, I see. And so, how would you say that South African law protects, or would you say that it does not protect creative works in South Africa, such as music, films, and TV shows?
It does, but we don't have a registry for copyright in South Africa, unlike the Americans. So but that doesn't mean that you don't have copyright protection. It just means that the copyright will subsist as soon as the work is original and reduced to material form, right? Whereas the Americans, it's still that, but they can, and I'm just choosing America as, a comparative jurisdiction I can speak about, but there are obviously many others. The Americans have actually a copyright office, much like we have a trademarks office. So the only time you can register copyright in South Africa, it's for cinematograph works.
That is so interesting.
But music, yeah, but musical works and so forth, you're gonna have to, as soon as you reduce it to material form, copyright will subsist. So you still have the protection, but no registration or depository.
Oh, so if I'm under just to check if I understand you, is a registry like a platform like maybe CIPC where there's a tab that says
Yes, yes,
copyright and it will list everybody's copyrighted works and for how long they are going to
yes.
have protection for. Is it that kind of thing?
It's basically a CIPC. Our CIPC doesn't include the copyright of musical works.
Oh, oh
Yeah.
my.
And something important to consider that people usually make the mistake of. Uh, Places like SAMRO, where you register your music, people think that you go there to register your copyright, which is not true. That's why the word register is very misleading when we speak about collecting societies. You're not registering your works, you are notifying your works. So basically, you're telling them of a work that you've created so that they can go and collect the monies and pay you. That's all. You know, uh, yes, having registered the song might come into play from an evidentiary point of view, should there be a dispute about who came up with the song first. But you're not going there to register your music. You're going there just to notify them of your music so that they can go out to SABC and collect, and other users to collect on your behalf.
Wow, that sounds like
Yeah.
such a short-changing it sounds like artists are really shortchanged in that sense. Because one would think that a
How so?
collective society would also then somehow factor in the copyright aspect of the law.
Yeah, I hear you, but just pay attention to the word collecting society. Their mandate really is to go out there, find the money for you, and pay it to you. Yeah, they don't get involved and, but there's some value add services that they do. They can hold mediation and so forth at no cost to their members, but they are not in any way. They don't play an adjudication role or a registry or a depository.
Oh, thank you for that. So, how do you advise clients on protecting their IP rights from infringement and piracy?
So you need to make sure that you keep all your records. Keep all your records. If you've worked on a song, and another thing that often, and I know this deviates a bit slightly from your question, is musical works are usually done in collaboration. So a lot of the time, you'll find that the ownership percentages are themselves are in dispute. You understand? You and I go into studio, but we don't sign. It's a document called a split sheet, designating our respective percentages in a certain work, right? And then you find now when Samro and them go and collect the works, they don't know what percentage to pay to who because you and I didn't agree on that at the time of creation. So that's the one thing copyright owners need to protect themselves from each other. Because as soon as a song, it's like clockwork. We've seen it happen all the time. As soon as a song blows up, everyone starts forgetting what they agreed upon verbally. We saw it, and I'm not casting aspersions here, but we did see one of the biggest songs to come from South Africa have that type of dispute, Jerusalem.
Yes.
The two main artists on that song were at odds about the splits.
Yes.
So it's those type of things. A lot of disputes actually emanate from the collaborators themselves, never mind third parties.
Oh, wow. That is very, very it's something that we do see play out quite often. And it's interesting because I've heard the term split sheets before, but I didn't quite understand what it is and what role it plays in protecting one's IP rights, especially for musical works. So then how does South African entertainment law regulate the use of IP rights in licensing, merchandising, and other commercial activity?
Well, there isn't much regulation. Sorry, there was a bit of feedback there. There isn't much regulation. A lot of these things are governed by contracts, but obviously we have a Patents Act, we do have a Trademarks Act. So as long as you're acting in the confines of that particular legislation, you're fine. And as you can imagine, trademark don't play such a pivotal role because you're just protecting a name there and a brand. Well, they do, but I mean, if we're talking music, the role of trademark is not as prevalent. Of trademarks is not as prevalent as that of copyright. So okay, there's the Copyright Act as well, but largely these things are governed by contracts.
Okay, I'm so glad you mentioned trademarks and how it doesn't play such a huge role when it comes to musical works. Can you explain what are the differences between trademark and copyright protection, and how do they apply to branding and marketing? Recently, I saw social media upset over somebody who, was upset that somebody used their tweet, their pinned tweet rather, and people were saying, but have you trademarked it, and that kind of thing. And so it was just an interesting discussion there. So can you help us figure out, or rather understand better, the differences between trademark and copyright protection?
Okay, trademark is more basic. It's just anything that's capable of being graphically represented, a mark. It serves as a badge of origin. So a trademark needs to tell you where certain goods and services come from, right? And, and it's very important for a trademark not to be descriptive of the services, otherwise it falls flat on its feet. What do I mean by that? If I am selling fruit and the name of my brand is called Apple, CIPC is gonna chuck that thing away because it's too descriptive of the products that I'm selling.
Oh,
However, if I refer to my product as Apple and I'm selling software and hardware, it's a perfect trademark
wow.
because it's not descriptive of the goods and services, right? And it's a badge of origin. You already know that if it's Apple, the proprietor is Apple. So a trademark tells you where something comes from, right?
Yes.
And then copyright protects music and literary works. There's a group of works that it will protect. But the main ones, at least in this type of field that we're speaking of, is musical and literary works, right?
Mm.
And unlike a trademark will be, with a name. So a name is quite short in nature. A trademark wouldn't be able to protect a book, right?
Mm.
But it would be able to protect the name of a book, right? But copyright will be able to protect a book, right?
Mm.
And you don't have exclusivity over the words themselves, but you have exclusivity. Exclusivity on the how do I say the material expression of those words. So if I arrange the words in a certain way, copyright subsists in that particular expression of the words, not the words themselves.
Yeah, that is very clear. I like thank you for that explanation. So what have you found to be the most common disputes centered around IP, and how do you approach resolving them?
So in the film space, the main one is this thing of I actually had a client recently who had this type of issue. It's the unsolicited proposals to channels, TV channels. You know, have a certain you have a certain idea of a show that you're looking into, and you are sending these things to the channels, and the next thing you find that the channel is using a very similar idea, but you and them never had any sort of agreement, you know. And a lot of the time, the people who send these things will go on social media crying that, yeah, they stole my show, they stole my show, you know. So there's an issue there because, um, yes, copyright might subsist in your work. You see, here's the thing: the threshold for originality with copyright is not that stringent. You know,
Mm.
you and I can come up with the same thing. That's another thing. Copyright doesn't protect ideas, only the material expression of ideas. So if you and I if I decide to open a chicken shop, but the chicken shop is is let's say it's a new thing to sell chicken from a caravan and no one has done it before. Copyright is not going to protect that because it doesn't protect ideas, but it will protect the manner in which my caravan looks, the colors which I chose, the arrangement of those colors for my caravan, you know. Now copyright comes into being, you know. So the same with a show. If you came up with a show about a divorced couple, there's many other shows like that. Copyright wouldn't protect it in any event, but you are looking to protect the way in which you protected those characters and whatnot. So what usually happens is that the broadcasters or the production channels, they'll deviate somewhat from what
Mm.
you have given them. And I don't mean to cast aspersions on any particular show, but there are some instances where you can see, no, they did use that person's idea, but So what? There's no law protecting them. So in such instances, you would have to give these guys an NDA at the very least to say, hey, listen, here's a show. Here's an idea. If you don't like it, don't disclose it. Don't compete with me on this show. I can take it elsewhere. At the very least, if it's like that, you'll be able to hold them, uh, on the basis of the four corners of an agreement. Going the copyright route is always a long shot because now you have to prove all these things. But if you have an agreement, you're holding them on the basis of breach,
Hmm.
you know. So that's one of the main disputes, at least in the film, on the film side of things.
Okay. So then how do you then advise clients on negotiations and drafting contracts such as non-disclosure agreements, talent agreements, distribution deals, because those are such common disputes in the space.
Yeah. Well, the first thing is stop going to the internet and getting there's no such thing, as you would know, as a standard contract. So stop going to the internet, because in any event, those things are, well, number one, they don't speak to your unique circumstances. And number two, it's usually American things that don't even apply here. So invest in a proper professional who can look at these things and advise you according to your specific needs. And if you are assigning any copyright of yours, um, let's see if the terms of the said assignment transfer. Assignment is another word for transfer. If you're transferring any copyright, let's see what the terms are and whether you can get that copyright at a later stage or maybe not. In some instances for commissioned works, you're not going to own the work. The channel will want to commission the work, as is. But how does it work out for you? How much are you getting paid for the said commission works? All those things.
Ah, I see. So
Mm,
then, is there
mm.
such a thing as thinking about IP too soon? Looking at how a lot of content these days is shared online, be it films. I mean, short films are being shared online. All kinds of things. Music is everything is like now people are doing like they are bypassing the current system whereby we're used to seeing things on TV only, right? So how soon is it ever too soon to think about IP? Is it too soon when I'm talking about my idea with a friend? Is it too soon when I'm posting something on TikTok that's an original idea? Is there such a thing?
You must think of IP immediately. Ironically, with what you're saying, the fact that you have now broadcasted the work first might even work out in your favor at times, because you can show that, wait a minute, I'm the first at a certain date. I can show that, I broadcasted this, and this goes a long way into showing that I came up with it. Although it's not a bright line rule, there could very well be someone who came up with that thing and doesn't broadcast it, but it's not, because artists at the end of the day need to. The world has changed. We don't have to wait for broadcasters anymore. We can broadcast ourselves. you know so if you can show, because I've seen a lot of times, to your point, a lot of people, when they're working on a song, or they've worked on a song already, but they'll play a short clip of it on social media to get people interested, you
Mm,
know because we don't have a copyright registration system in any event. What are you actually waiting for? you know
mm. And so how have our laws
yeah.
evolved? How have our laws evolved to keep up with the tech advancements and the rise of digital content distribution? Have they evolved? I'm
Yeah.
worried. This is
So
like you never know with our laws.
yeah, no, they haven't. They haven't really, or they're doing so at a slow rate. But we do have the Copyright Amendment Bill that
Yes.
is on its way, but it is not without its blemishes, unfortunately. It has a lot of issues which the industry has a problem with.
Mm.
Can I go into
Yes,
to
by
the said
all,
issues.
yes, yes, most certainly.
Yeah, yeah. So one of the main issues is they've included a fair use, a very broad fair use exception. So fair use is basically not all not all use of copyright, another person's copyright constitutes infringement. Sometimes there are exceptions, right? We do currently, in our current copyright regime or act, we do have an exception regime called, or clause called fair dealing, right? And it has a very closed set of exceptions, right? However, with the incoming fair use, now they've changed, but it's not just a title change. They're calling it fair use in a very American style, but that fair use clause is more open-ended.
Mm.
And as a lawyer, you'll know yourself that when something is open-ended, there's only one forum in which only one forum is going to give a true position, right? And that's the courts.
Good.
Who has money to run to the courts in the creative sector all the time? You know, that type of clause, it does much better in America, a very litigious place, and where the people have resources to to run to court. We just saw recently Ed Sheeran, um, the co-writer on one of the Marvin Gaye songs, took
Yes.
Ed Sheeran to court on an infringement basis. That would never happen in South Africa. Well, I wouldn't say never, but it hardly happens. Those type of disputes resolved in boardrooms and so forth. But now we have this very, very, very broad fair use exception, which is going to have a devastating effect on the industry.
Mm. Yo, thank you for sharing about the copyright
Mm.
amendment bill and how fair use is different from how it was previously used in the old act. Um, so then what are the key differences? As you've mentioned, in America, people are different. They have a different adversary, they have a different legal system altogether. So when it comes to collaborating with international projects, what are the differences between South African IP laws? How do you navigate these differences for your clients?
A lot of the times, we're all part of certain treaties which makes our laws uniform to a certain degree. So they also have a copyright in the master recording. They have a copyright in the composition. So you can still negotiate on the same basis with a US artist. In fact, I have experience in doing that. With some of the people I've worked with and for. So the concepts remain largely the same, even though there are nuances here and there.
I see, I see, I
Because
see.
those are the two main copyrights that so a song has two copyrights. It's the copyright in the composition, that's the melody and lyrics, and copyright in the sound recording, also known as the master, that's the actual recording of the sounds.
I
Yeah.
see, I see. It's helpful to know. I usually thought that there's a huge difference and they have to go through months and months and months of sorting out the legalities before a project can be released. So it's interesting to hear that it's actually quite similar on a foundational level, and there are treaties in place to also help regulate how they work together.
Exactly.
Okay. And how do you see the future of IP in the South African entertainment industry, especially in light of the ongoing digital transformation?
Well, nice thing is that people access to information is much better these days. You can actually go to TikTok and find someone like me speaking about these things for free, you know? So, yeah, there's an awareness and people know, they're in a better position to invoke, um, certain laws. And the way in which the business is these days, the barrier to entry is definitely better because you needed to be signed to get your music out there. You needed to for someone to sign you and get your music onto the SABC or to Musica for someone. Well, well, let me just say retailers and not name the actual retailers. Put your music to retailers at if you think about CDs, the cost and distribution cost of transporting a bunch of CDs, putting them across stores across the country, it used to be crazy. Now, now, all I need is this. I press a button and I can be heard all over the world just by the press of a button, right?
Yes.
And to get on, the retailers are different now. The retailer, Spotify and all the other retailers, you can get onto those retailers for next to nothing globally. You see, so it's there's an awareness and the barrier to entry is just much better in the
Oh.
music business.
Is entertainment law a big area of practice, or is it more niched in South Africa, considering the current state of the
In
industry?
Yeah, look, in South Africa, it's a very niche field. Um, I chose this direction because of the love of it, but from a commercial point of view, there is a gap because you ask a general lawyer about the stuff I'm talking about now. They're not going to be able to, not all of them, of course. I mean, some of my work I get from general lawyers as well, because they don't want to deal with this stuff. You know,
Yeah.
it's so niche, and the industry is very small.
Hmm. So, what does it mean for
Mm,
you to be able
mm.
to practice for your own account in this specific area of law? I heard you mention that you went into it because, for the love of it. So, can you please just tell us a little bit more about that and your motivating factors?
So it's always been a dream of mine. Let's put it like this: I'm a music lover first and foremost. I everything about me, when you see men sitting in front of a TV and screaming at the TV because they're watching their favorite team. I'm on YouTube watching my favorite artists dissecting what they're doing, the history in which certain albums came out. That's what I do in my free time. I've always done that. Music is just flows in my veins. It's just that I'm not talented. I don't have any talent, but I don't wish to participate in that capacity. Um, I'm a consumer of the arts, but I've always wanted to contribute to the arts somehow. And I found that I could apply my legal experience to this specific field so that I can work and it doesn't feel like work. Look, I love law in general and love law in general, but this is the only area that I could do for free. But I don't encourage anyone to contact me for free uh, work. But if I could choose which area of the law I do for free, it would be this one.
That is,
Yeah.
that is a clever way to approach it. So lastly, if there is somebody who's listening to the podcast today and wants to get in touch with you, is in the entertainment industry, or knows someone who is, where can they find your offices and what are your necessary contact details, social media handles?
Geez, I don't remember all those things off by heart. I have to look at them somewhere. I have to,
Apologies for the ambush.
yeah, I have to look at them. I don't memorize these things. Yeah, yeah, that was a proper ambush. So, our offices are in Rosebank, at the Firs.
Okay.
Yeah, there's where when you go to Rosebank, the mall, there's a place called the Furs. Our offices are within the Furs. And we're available on Twitter and Facebook. We're working on Instagram presence as well. We're also on LinkedIn, and our website is www.mdakanelaw.co.za. Apologies. And our email is info@mdakanelaw.co.za.
All right, got it. And for anyone else, just to wrap it up, the name of the firm is Mdakane Attorneys. So
Yes, Mdakane Attorneys Inc. Yes.
yes, Mdakane Attorneys Inc. Well, thank you so much for joining us, Bongani, today. I do hope that I wish you practice all the success. And thank you that people like you exist to help out in the entertainment industry and that you do it with so much love and passion.
Thank you so much. Thanks for having me. I had fun talking about this stuff. I enjoyed this.
Okay. Thanks.
Sure.